Hi, thanks for having me. Steve, I'll speak to you directly. I think this is a thoughtful, thought-provoking, elegantly written paper. I think it's absurd that you're in your first year of law teaching and you produce something this good. So congratulations to you. I enjoyed it very much. This provides, I think, an extremely useful vocabulary for thinking about a lot of problems that you identify. It turns out that I've been writing about certain kinds of backdrops for several years now without understanding that and without having theorized sufficiently about them. So I, in particular, am grateful for this paper. You talk about three types of backdrops: the textual incorporations by reference, which I think you appropriately say are, and they're important to identify here, but less interesting than the other types. And the second one you talk about is where text leaves in place pre-existing rules by expressly insulating them against change by other legal actors. Your example there is interstate borders and interstate border disputes. I'm not going to say this definitively because I'm sure there's some people here who can prove me wrong, but I'm trying to think of other examples of that where the text expressly insulates pre-existing atextual rules from change. I'm having a hard time coming up with some. My suggestion is maybe only that this might be actually a quite small category of backdrops, your category 2. Category 3, as you recognize, is, I think, by far the most interesting and generative of important insights. And this is the category where, as you point out, the language of the Constitution is presumptively defeasible, and that the text can be limited by pre-existing atextual legal rules that come from non-constitutional sources, primarily the common law or the law of nations. And I have a couple sort of categories of points to make about those. One category of points I think I'm going to just call sort of general housekeeping. This might be an inapt description, but what I mean is that this is a work in progress, and it strikes me that there might be places where there's ways that you describe this category and ways you describe backdrops that don't always fit with each other, and I think that simply might be because we're dealing with a draft paper, not because there's any problem with the theory. But secondly, I want to push a bit on sort of the contours of this category of backdrops and suggest that maybe some of the objections to them are perhaps a little stronger than where you came out. So the first category of things I wanted to say is I got sort of an inconsistent message, I think, on exactly how this category of backdrops works, and in particular on how and whether they're insulated from change by other legal actors. So in a number of places, you seem to define a backdrop as something that is, in fact, insulated from change by some part of the constitutional text. In other places, you suggest that a backdrop is definitionally something that's insulated from change, but not necessarily by text, but perhaps by unexpressed textual principles or postulates, by structure, maybe possibly even by other backdrops themselves, although I'm not sure about that. But then the discussion of the feasibility of the text opens up by saying that this category of backdrops, quote, may or may not be entrenched against new legislation. But then right after that, and again in one other place, you suggest that for this third category of backdrops, they perhaps may only be able to be changed by constitutional amendment. I think my bottom line is you've identified an incredibly important type of issue, the backdrop issue. You've raised a lot of interesting questions about it, but there might in fact be a great variety of backdrops. The answers about whether or how they're insulated from legal change likely vary substantially across the different types of backdrops, and it perhaps might just not be possible to say anything that uniformly applies to all of them. So going further on this third category, so you have a positive project, and I think the positive project could be essentially said to be sort of how is the Constitution drafted? What legal assumptions and background assumptions about the nature of legal texts were the drafters operating with? And I think on this sort of positive question, it strikes me that you got it right. I mean, I'm quite convinced that the Constitution was written with a background assumption that the general language was defeasible and could be defeated by non-constitutional legal rules, in particular the common law and the law of nations. I mean, that strikes me as exactly right. Just as an aside, you provide some evidence that this, in fact, was specifically understood to be the case, from Madison at the Virginia ratifying convention, to the extent that there's other easily deployed evidence to show that this, was in fact a view held by, by drafters and ratifiers. I think that'd be great to put that in. But even without that, it strikes me that you must be right that that the Constitution was written with an assumption that its broad language would be defeasible by non-constitutional legal rules. And I think it's incredibly helpful to make that point, to foreground that point, and I think you definitely point out the right types of questions that we should be asking about, by adopting this category of backdrops. Asking questions like, what specific parts of the Constitution's text were, understood to be defeasible, which specific rules of non-constitutional law did in fact, or were in fact understood to limit or defeat those parts of the text, and then which government actors, if any, were empowered to change those backdrop, non-constitutional legal rules, whether it's Congress, the President, the federal courts, state legislatures, or perhaps no one in the case of a backdrop that might be entirely insulated against legal change. So I think it's an incredibly successful paper, for giving us this vocabulary and sort of pointing out the types of questions that we should be asking. And a couple of points where I might, push back a little bit. The paper seems to reject the idea that common law or law of nations, when functioning as a backdrop, could be changed or updated by the courts. I don't have a definitive view on whether that's right or not, but I think the answer might be that neither did the founding generation. There was a lot of, in my understanding, there was a lot of sort of confusion and contradiction in terms of what precise legal status the common law and the law of nations were thought to have vis-a-vis the new constitution that was being adopted. You're definitely right to point out that there was a sort of a heavy sense, and many people had in this pre-positivistic period, that this was general law that just existed out there in the world, and that the role of courts was to find this law, not to be making it or updating it in any sense. But there's also many indications that I've seen that that members of the founding generation were sort of more positivistic or more modern than that they actually understood that the law of nations and the common law both did change over time as a result of intentional policy decisions. One thing I'm thinking about is controversies about prize law and issues about whether free ships make free goods or whether other prize laws should be applying. A lot of prominent members of the founding generation very specifically wanted to update and change the law of nations and understood it not to be some body of law that was just out there in the world existing, but something that something that did in fact change as a result of government action. And so when the Constitution extends the federal judicial power to cases in admiralty, when Congress implements that in the Judiciary Act, I think a decent number of members of the founding generation would have thought that that was essentially a delegation to the federal courts to be applying and elaborating and updating as situations required this body of non-constitutional law. And without going into all the other areas of common law and the law of nations, I think it might be the case that there's a similar sort of ambiguity and mixed views about both the status of that type of law and what role the federal courts could play in applying it, whether it's merely sort of finding pre-existing law or whether there was more of a generative sense that they were updating and making law. Two objections that you raise. I think it's a terrific part of the paper, the third part where you list these various objections and try to respond to them. On two occasions, I thought the objections might have been a little stronger, perhaps, than you allowed. You have the sort of dead hand objection, which is that is this even sort of deader than the dead hand of the written Constitution, binding us to a textual, non-constitutional law that was never specifically voted on and adopted by anyone. And your response, as I understand it, is, well, the founders decided to make some rules binding by putting them explicitly in the text, and the founders decided to make other rules binding by silence, and that the second type of bindingness is no more deader than the first. I think that response probably probably could be stronger or need some more developing. Just because in discussing, why it was most natural to read the Constitution's text as defeasible, you argued, and I was persuaded, that the drafters of constitutions or texts often don't know about and shouldn't be understood to have taken a firm position on, shouldn't be understood to have reached an agreement about all of the voluminous background rules that might be possibly defeating the plain text. And that strikes me as that's probably the best understanding of what the founding generation's relationship to the law of nations and the common law would have been. That some general sense that it might in various ways be defeating otherwise broad plain text, but not having reached an agreement about every single place where that would be true. And if that's the case, then I think there actually is sort of a deader hand than in the case of explicitly voted on written text. For me, that's not a dispositive objection against understanding the Constitution this way, but I think it's maybe a little bit stronger than you said. And secondly, on the indeterminacy objection, you said does recognizing that there are unenumerated powers or unenumerated rights that come from non-textual sources, other sources of law, does this open up a Pandora's box of indeterminacy? Your response was that your backdrops theory, you said sort of that the only thing that matters is whether the history is right or whether it's baloney. You said the backdrops theory gives precisely as much weight to claims of unenumerated rights or powers as they deserve, according to what the historical record supports. It seems to me that this maybe sort of doesn't fully grapple with some of the features of the written Constitution that are normatively attractive to a lot of people. One feature that the writtenness supplies is a constraint on judges. It's widely thought. I'm not saying if that's right or wrong or good or bad or whatever, but I think it's it's widely thought that that one thing that a very text-based originalism does well is constrain judges, and it strikes me that people who find that to be an important value would have a serious indeterminacy problem with your approach. And then the second feature of writtenness that's normatively attractive to a lot of people is the democratic legitimacy that comes from the specific words having been debated and voted on and adopted by the people through supermajoritarian means. If you're right, which I think you are, that drafters would not have specifically reached agreement about all of the features of the common law or law of nations that we're going to be serving as backdrops, then it strikes me that the indeterminacy about that is perhaps normatively problematic for people who place who find originalism attractive because of the democratic legitimacy that voting on a written text gives. But as I said, I think this is a terrific paper, and I really do congratulate you for it.